Welcome back to the channel, where we break down the most jaw-dropping courtroom moments. Today, we're diving into the case of State versus Anthony Wayne Monty, a man standing trial in Texas on a controlled substance charge. Now, before you think this is just another open and shut drug case, think again. This hearing is packed with legal maneuvers, emotional stakes, and a judge who's balancing the scales between punishment and rehabilitation. Here's what's at stake. Anthony is charged with possession of a controlled substance under 1 gram. That may sound minor, but in Texas, even a small amount can carry up to 2 years in a state jail facility and a fine of up to $10,000. The real twist? Prosecutors are offering him something called deferred adjudication. If you're new to that term, it basically means Anthony can avoid a conviction if he completes strict conditions like treatment, probation, and community service. Mess up, and that leniency vanishes, replaced with hard jail time. But here's where it gets even more interesting. Anthony's defense is painting a picture of a man fighting for sobriety, a man whose life revolves around treatment programs and AA meetings. Meanwhile, the state is cautious, but willing to reduce the charge and set conditions. Will the court see him as someone deserving of a second chance, or as a repeat risk who needs punishment? Stick with us, because as this unfolds, we'll see Anthony face tough questions, his lawyer plead for mercy, and a judge who clearly wants accountability but also believes in redemption. And later in this hearing, there's a powerful moment where Anthony's responsibilities as a father come into play, shifting the entire tone of the case. So buckle up. This is more than just legal paperwork. It's a battle between law, mercy, and personal redemption. Let's get into it.
I asked her to secure a better connection. Okay.
Court is calling 2025 CR 0070015. State versus Anthony Wayne Monty. Can I have parties announced for the record?
The for the state of Texas, Your Honor.
Christine McDonald for Mr. Muncie.
And are you Mr. Muncie?
Yes, ma'am. Yes, Your Honor.
Thank you. Oh, thank you. All right, counsel, have you received all discovery? And did you review it with your client?
Yes, ma'am.
Court will find that the state is in compliance with discovery. Mr. Muncie, did you review the application for deferred adjudication with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
No, Your Honor, we are not. We are proceeding with the lesser included possession controlled substance penalty being 1 less than 1 gram to make this a state jail.
Any objection?
No, Your Honor.
Did you review the court admonishments with your?
Whoa, did you catch that? The prosecution just dropped the original indictment and agreed to proceed with a lesser charge, possession of less than 1 gram. That's a huge shift. In practical terms, this move lowers the maximum penalties and opens the door wider for probation or treatment-based outcomes. Why would the state do this? Well, prosecutors often reduce charges when they believe rehabilitation is more effective, or when the evidence for harsher charges isn't as airtight as it first seemed. But let's be real. Even a lesser felony still has serious consequences. Question for you all. If you were in the prosecutor's shoes, would you have made that deal or pushed for the tougher charge?
Attorney, did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
You're charged with possession of a controlled substance penalty for 1 less than 1 gram. That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you. and you will be allowed to withdraw your plea. Did you understand? You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 2 years in the state jail facility and up to a $10,000 fine?
Correct.
Counsel, has your client been able to provide you with any defenses?
Yes, sir.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes,
Sir, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea bargain agreement, the state is proceeding on the lesser included offense. There is to be deferred adjudication, restitution of $60 to the Bexar County Crime Lab, follow the recommendations of the TAP evaluation. Did you understand that to be your plea?
Yes, Your Honor.
Defense, is that the plea?
yes, sir.
State, is that the plea?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
No, Your Honor.
Outside the agreement, the state is recommending.
Right here's the turning point. Anthony's agreeing to 2 years deferred adjudication, along with restitution, community service, treatment compliance, and even medication monitoring. Let's break that down. He avoids jail time for now, but lives under court supervision with zero margin for error. One slip, one missed drug test, one probation violation, and he could end up serving the maximum. Think of it like walking on a tightrope without a safety net. And here's something worth asking. Do you think deferred adjudication is truly a second chance, or just a delayed sentence waiting to happen?
That your deferred adjudication be for a term of 2 years. There'll be 100 hours of community service restitution and take all medications as prescribed. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to the offense, the lesser included offense, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
State offers State's Exhibit 1 and all attachments, Your Honor.
No objection, Your Honor.
All right, state, you may excuse.
Thank you, Judge.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments, and the court will review the same. After reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Your Honor, just that I spoke with his case manager this morning. He's doing excellent in treatment. His whole day revolves around treatment, Judge. He has group first thing in the morning, group after lunch, and AA meetings after dinner, Judge. He's doing excellent. We're asking you to take that.
Powerful moment here. The defense is reminding the court that Anthony isn't just fighting addiction, he's indigent. That means he can't afford standard probation fees, and his attorney is basically pleading with the judge to ease that burden. Think about it. How can someone rebuild their life, stay sober, and meet treatment demands if they're drowning in fines they can't pay? It's an often overlooked reality. Financial pressure can derail recovery faster than anything else. Should courts be more flexible here, or does everyone need to shoulder the cost of their mistakes, no matter their financial situation?
In consideration with the conditions that the state put, I believe it was minimal so they can focus on his time at ITP and residential treatment judge. And one more thing, Judge, my client has been declared indigent by this court, and if there's any consideration you can do on the monthly probation fees, that would help him out immensely as well, Judge.
So how you doing?
Day by day doing my.
Oh, that's good. Yeah, they say you have to take it day by day, but I'm so happy that you're working towards staying clean and sober.
Appreciate it.
All right. So what I can tell you with regards to fees to probation, I take everything in consideration when that's presented to me.
Yes.
Okay. All right. The court, do you have children?
Yes, I do.
What are their ages?
8 and 10.
Okay. Court is going to sentence you to 2 years deferred adjudication. There's $60 restitution to Bexar County lab for drug testing. 100 hours of community service restitution. Once he completes parenting classes, the community service hours will be deemed satisfied. There's to be regular reporting by Zoom or in person, regular random UAs, and probation. If he's receiving the UAs through the treatment program at.
And there it is, the final ruling. Anthony is sentenced to 2 years of deferred adjudication, 100 hours of community service that can be converted through parenting classes, mandatory drug testing, treatment at Haven for Hope, and $60 restitution. The judge makes it clear, this isn't punishment-free, it's structured accountability. The message? If Anthony sticks to treatment, stays clean, and fulfills every condition, he can walk away without a conviction. But if he slips, prison doors swing wide open. This case raises some big questions. Is deferred adjudication the best path for nonviolent drug offenses, or is it just pushing accountability down the road? And how much weight should financial hardship carry in sentencing decisions? What do you think? Did the judge strike the right balance between compassion and accountability? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns. Until next time, stay sharp.
Center for Healthcare Services, that's acceptable to the court. But if not, you have to do your UAs with probation. There's to be continued treatment with the ITP program through Center for Healthcare Services on the Haven for Hope campus. And you need to sign a release so that probation can make sure that they receive updates on how you're doing.
Okay.
All right. And probation, you all don't do field visits at Haven for Hope. Is that correct? All right. And we'll do a TAP evaluation out of custody just so that we can have that. Probation, is there anything else? I really, not right now. I want him to focus on his mental health and focus on maintaining his sobriety because he's at Haven for Hope. All right. Is there anything else you need from the court to be successful?
No, ma'am.
Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with you?
Yes. Yeah.
Did you understand it?
Yes, sir.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes.
We can go off the record. I congratulate you on, maintaining your sobriety. But in this court, if you feel like you're going to use, first of all, make sure you make use of the tools that are being given to you for that. And then if that's the case, you can always call probation. And you know what will happen? I will have a compliance hearing This will probably be your attorney. We'll come in here and see what we can do to help you maintain your sobriety, okay?
Okay.
All right, good luck to you. Just remain in the courtroom. Probation will go over conditions.
All right.
All right, thank you.